everyone. Wajay Misaway, Michael Etherington discussing Mushkego Nina. I'm originally from Treaty 9, Janeville area, Mushkego territory. Currently, I am the manager of ReconciliACTIONs with the Downie and Wenjack Fund. And this presentation today is in alignment with Treaty Recognition Week, an annual event held on the first week of November in the province of Ontario since 2016. The title of this presentation is We Are All Treaty People. Conversation we wish to share today in regards to treaty awareness and education for Canadians. As highlighted in the original statement, it references the importance of treaties to help students and residents of Ontario to learn more about treaty rights and relationships, which can extend to the broader scope of a national narrative. To begin, I'd like to highlight the core theme of this conversation, which is in regards to relationships. As many treaties from past, present, and future, a central theme resonated with many Indigenous nations, which is the acknowledgement of respect, renewal, cooperation, shared prosperity. Unfortunately, there are at times ongoing challenges with the interpretation of treaty, the honoring of treaty, and broken promises. For someone like myself, residing in an urban area, and also for many of us who may currently live even in remote rural communities, the interpretation of treaty will vary today from an Indigenous, non-Indigenous perspective. But for someone like myself, I considered where I'm from. And I want to share this visual with you here, which is a tamarack goose. Now, these are made through tamarack, that you can see here. In past, they were used also as hunting decoys. And if you go further back, the tamarack was also used as medicine. Today, at times, some community members may solely interpret these and those who purchase from community members as decorative pieces of art. And that, to me, speaks to a bit of the context and conversation that we're having today with regards to cross-cultural understanding of treaties and how they're understood and interpreted. So for both Indigenous and non-Indigenous, is that how do we continue the original intent and spirit and meaning of what the treaties entailed for all of us that established the foundation of Canada? So as it highlights here, learning more about our collective treaty rights obligations to create greater understanding and how we can nurture those relationships. So today, the concepts we'd like to share with you today are with regards to treaty making, some of the treaty challenges, and treaty terminologies. If we were to look at it solely from an Indigenous perspective, one thing that I do want to highlight is that the interpretation of treaty will vary from nation to nation. So even if you extend it further back prior to contact of colonial groups, intertribal, inter-Indigenous treaty-making processes existed. The cultural context of that would be applied and interpreted. So one of the challenges I'm trying to highlight is that the core of the treaty understanding should be through the root of language. So Umashkego Kri Naskumituan is a mutual agreement. And then also Ichihim is about how we help one another. But those language concepts and terminologies are very much held with elders and community members who have maintained and the knowledge of the oral histories passed down to continue that education. So an important factor, just right from the onset, is that the interpretation of treaty also should be through the original language and also the original instruction. But a common concepts that are utilized in English that you see here are inherent rights to land, on ensuring that it's for future generations. You may have heard the concepts about for the next 7 generations, nation to nation, as established through the Royal Proclamation of 1763, the spirit and intent of treaty, stewardship of land, making a distinction between ownership and stewardship. So for many Indigenous nations, it's not about a sense of ownership because we cannot own the land. And also that stewardship goes beyond just a human to human form of interaction. It's also to steward, to look after the waters, the lands, the animals, the fishes, everything that is within our territories, is that it goes beyond us. And also the spiritual element in the ceremonial practice of tradition. So many Indigenous nations have that, and they carry within their worldview and understanding when these agreements were placed, these sacred agreements between Indigenous and also now what is known as the Crown, the oral agreements. So one of the fundamental challenges that you see here today, as well as how the interpretation of treaty is perceived from both parties, and those power balances that existed and still exist to this day, and concepts of Aboriginal title, which have been originally acknowledged through by King George III in the Royal Proclamation, and the treaty rights, some of the promises, obligations that became provided within regards to the treaty negotiations. If we look at moving forward for some of the original treaty making processes between colonial groups, I do want to highlight the two-row wampum, the Swanta belt. This is between the Haudenosaunee and Dutch, and you can see the date specified in 1613. Now, during that period of time in Canada was the fur trade. So through economics, trade, both parties had to establish a peaceful understanding to continue and further the economic and trade interests, but also to ensure that peace. So for a large period of time, around 100 years, there was what was known as the Beaver Wars. So one of these first wampum belts that you see between the Haudenosaunee and Dutch, one thing I do want to acknowledge is that as not being Haudenosaunee, but the principles we can all learn from with regards to the two-row wampum. They refer to the canoe and the ship and that linear path there is with regards to the river of life and the binding of the agreement through peace, friendship, and respect, and it's lasting forever. And also those treaty principles carried forward into the more common treaty negotiation that you see in quotes such as long as the sun shines, the grass grows and the rivers flow. So in perpetuity, these agreements will always be ongoing, and they've established a silver covenant chain of friendship, and saying that it always has to go through a process of renewal. And so how do we remind ourselves of our treaty relationship? One of the most important things I find for myself is that when we refer to treaty education, it at times get relegated to legalistic points of reference, which may exclude many Canadians. And so the two-row wampum, the Treaty of Niagara 1764, and many others that exercised those principles about how we can effectively live together, share these lands together, but also accept our role and responsibility to steward these lands, is where this conversation can move forward in regards to the journey of reconciliation. So when we look at the treaty making process in Canada, you had these three times and periods. So for example, the Inter-Indigenous Treaty, there was a common one that was agreed to in 2014 with many Indigenous nations in the West to look after the buffalo. But prior to contact, inter-Indigenous treaties did exist. So some that you can look at with regards to shared prosperity, one that's commonly referenced, you see is the one dish, one spoon between Anishinaabe and Haudenosaunee, and also inter-European treaties, that treaties that were enacted between colonial entities and transference of powers and jurisdiction, such as the ones that were established in Eastern Canada. But the ones that are currently recognized predominantly by the Crown, the federal and provincial bodies and territorial governments today are what are known as Indigenous Crown treaties. So the government of Canada today recognizes ones from 1701 to 1923 with regards to historic treaties, and then the modern treaties that were established from 1975 to present. So in Canada, the historic treaties currently around 70, and the modern treaties around 26 have been signed to date. So when we look at the treaty agreements, they are referred to as a nation-to-nation relationship. And with the Indigenous and Crown that established these agreements, both parties bring their worldview and perspectives, and through the process of negotiating, developing understanding, they would agree to terms. But as you get to more the post-Confederate Indigenous Crown treaty-making processes, the Crown did present treaties such as the number treaties 1 to 11 that were written in form, and the Indigenous nations would agree to, but one of the processes they're missing is the oral interpretation of that treaty. So there was kind of this challenge with regards to what parties were agreeing to. So for example, were they agreeing to the written form of the treaty, or were they agreeing to the oral interpretation of that written treaty? And so these led to some challenges in the court and interpretation. But overall, though, when you look even in the pre-Confederate, Indigenous and Crown did have high levels of diplomacy on exercising these agreements to ensure that they were mutually understood between parties, such as the Treaty of Niagara 1764. If we looked at that context, the point of reference for cross-cultural understanding, a question I'd like to share is that if we were not provided the cultural context, teaching, meaning behind, for example, wampum belts, would you be able to understand its significance and importance to Indigenous nations, and also secondarily, the foundation of Canada as a country? So what I want to highlight is that if we look at our relationship as being treaty people, the knowledge transmission from generation to generation is that when we're having these conversations, is that various parties that are becoming involved today have a different level of understanding. So if we are moving forward towards the journey of reconciliation to further our understanding of trying to have peaceful relations, peaceful coexistence, is that we do have a variance of misunderstandings between parties, but how do we, in a cross-cultural space, promote that form of education and ongoing learning? So focusing here on the Indigenous nationhood and cultural identity, oral histories are a high level of form of diplomacy. So reciting various stories and accounts, especially through the interpretation and understanding of what the wampum belts signified. Formalities were adhered to also by colonial officials during pre-Confederate treaty making by reciting and adhering to this protocol of oral traditions. And cultural items with Indigenous nations require the oral history to contextualize the meaning and importance of items such as a wampum belt. So that's why when I referenced here as an example, is that if you were given a cultural item or a cultural piece, it may be interpreted solely as that from your worldview understanding. But if you look at the historical past and meaning, it carries much deeper significance for Indigenous peoples and the interpretation of their worldview. Now, also within the oral histories, they were applied to conversations associated with nationhood and land rights and interpreted in the courts. So they became vital to support Indigenous title, and also towards exercising treaty rights. So a few court cases such as Delgamuukw 97, Supreme Court stated the importance of oral history as important evidence that must be treated as equal. And the precedent of the ruling was referenced in future court cases, including Indigenous title rights, such as the Colton 2014 case. Now, with regards to the treaty making process between Indigenous nations, a significant date in Canada is the Royal Proclamation of 1763. So on October 7th, King George III issued a Royal Proclamation. And one of these it's a conflicting document for many Indigenous peoples. because it does say the jurisdiction lies with the Crown. But the interpretation of the proclamation are, one, the acknowledgement of Indigenous title, but ensuring the continuity of that nation-to-nation relationship, which is referenced in the Royal Proclamation. So you can see here the Government of Canada acknowledging reference, and that transference became constitutionally enshrined in Section 25 of the Constitution Act. That proclamation was developed without consultation of Indigenous peoples. And so Sir William Johnson had to send to many Indigenous nations an interpretation of the treaty. So at the Fort Niagara, during this period of time, there were around 2,000 Indigenous delegates and representative of 24 nations who came together to gather and through negotiation for weeks on end, signified this treaty, and also to acknowledge the proclamation to ensure that peaceful relations would exist with the Crown. But the importance of the proclamation was to provide and allow for continued settlement with settler groups, but also to deal exclusively Crown. But this interpretation also was challenged with regards to how it was certain promises were not acknowledged. So, for example, there was these gift exchanges that would occur annually, and over a period of time, those annual meetings and gifts exchange and the council fires over a period of time were not honored. And so today, in one of the TRC's 94 calls to action, it does state, we call upon the Government of Canada on behalf of all Canadians to jointly develop with Aboriginal peoples a royal proclamation to be issued by the Crown. The proclamation built upon the Royal Proclamation of 1763, the Treaty of Niagara 1764, and reaffirmed the nation-to-nation relationship between Aboriginal peoples and the Crown. So for many Canadians, we are moving forward with the 94 calls to action following the TRC's final report published in 2015. And one of those calls to action, specifically 45, has a few subclauses in there, but more specifically, if you speak to your local MPs or MPPs, you can reference this about raising the awareness with regards to continued Royal Proclamation, but also honoring the original sacred agreements that were held during the Treaty of Fort Niagara 1764, which we are all treaty people for. In this map of Canada that you see here is acknowledging the treaties that currently are acknowledged by the Crown, which is the Government of Canada. And you can see between here, treaties 1 to 11, some of these pre-Confederate treaties, the peace and friendship. So if you want to break this down here, if you look at the treaty-making process of historic treaties, as mentioned, between 1701 to 1923 are predominantly here in these regions. And then what happened after 1923 and the treaty adhesions in 1929 for James Bay number 9 treaty, there was a treaty-making process that did not continue until the 1970s in enacting the modern treaties of the Comprehensive Land Claims of the James Bay Hydro Agreement 1975 in Quebec here. It was triggered by a Supreme Court case, the Calder case in 1973. And so these areas highlighted here are the modern treaties, but also there are 14 treaties known as the Douglas treaties in the Vancouver Island. So this is ultimately a broad scope of the treaties that currently exist in Canada. But one thing I do want to highlight here is the visual aid of the two-row wampum here in the logo. So when we mentioned those inter-Indigenous, intertribal treaties that existed pre-contact, and also too, with the British monarchy following the Treaty of Paris, there are certain treaties that became null and void. And France ceded lands to the British following the 7-Year War. So here, historic treaties recognized by the Government of Canada. You have treaties of peace, neutrality, treaties of peace and friendship, Upper Canada, Williams treaties, Robinson treaties, Douglas treaties, number treaties 1 to 11. And then also highlighted are the modern treaties to date, 2016. And also one of the more recent ones where it was the final agreements were established in 2016. So modern treaties are also known as comprehensive land claims, and when they are established and finally agreed to, they are known as the final agreements, and they are fairly comprehensive in scope with regards to allowing land and resource rights of Indigenous signatories and intent to improve social, cultural, political, economic well-being of Indigenous parties concerned. Now, moving forward into the 1980s, you had what was known as the Constitutional Express. So many of us do reference Section 25 and 35 of the Constitution Act, but in the original drafting of the Constitution, they were not going to be included. So for historical points of reference, in the 1960s, 1969, there was a policy paper known as the White Paper. And as a result, the head of Indian Affairs, former Prime Minister Jean Chrétien and former Prime Minister Pierre-Éliott Trudeau were drafting that a policy to absolve the Indian Act, franchise Indigenous peoples into the Canadian state, which was met with quite opposition. And Harold Cardinal published what was known as the Red Paper. Now, during that shift, that did create a mobilization of international unity of Indigenous peoples. And so during these constitutional dialogues, this movement of Indigenous peoples, which started in Vancouver, went to Ottawa, it was met with opposition and fell on deaf ears. And so as a result, these conversations continued to the international stage in both London and New York. And eventually, as a result, the Indigenous rights and treaties became enshrined in the Constitution. So you had Section 25 and 35 of the Constitution Act of 1982. And it states that the guarantee in this charter of certain rights and freedoms shall not be construed as to abrogate or derogate from any Aboriginal treaty or other rights and freedoms that pertain to the Aboriginal peoples of Canada, including any rights or freedoms that have been recognized by the Royal Proclamation of 1763, and any rights or freedoms that now exist by way of land claim agreements may be so cried. And then secondly, for Section 35, there are 4 clauses, but I'm only referencing Section 35(1), which states the existing Aboriginal treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. So between the Government of Canada and Indigenous peoples, you have what is known as Crown relations. And it states that the British Crown entered into treaties with Indigenous nations to support peaceful economic and military relations. And a few comments that are concepts that you see existing between the federal, provincial, territorial governments are concepts such as fiduciary duty, honor the Crown, and the nation to nation. So the fiduciary duty of the Crown acts as a trustee and in the best interest to negotiate honorably with Indigenous peoples. Unfortunately, though, you can see evidently some of these ongoing challenges with regards to the treaty interpretation that is held within Section 35. So as a Crown representative, these are some concepts that may be held between the parties. So as I mentioned in the worldviews that are being brought forth between Indigenous nations and the Crown, well, what are some of these legalistic terms? So when I consider the conversation about we are all treaty people, a lot of my emphasis for Canadians are some of those relational concepts. But unfortunately, in our educational processes, we refer to this nation-to-nation relations solely by a legalistic interpretation. And I find it doesn't resonate to carry the narrative of reconciliation forward if we want to look and examine about our relationships to each other purely from a transactional point of reference. And so that's the fundamental challenge that got us into the where we are today with regards to these paternalistic social policies, establishing Indigenous peoples as a ward of the state. So for Crown representatives, you may see here concepts that are continually referenced, such as the principle of discovery, justifying the sovereignty of colonial groups to dispossess Indigenous peoples of their land, extinguish their rights of treaty, occupation, possession, conquest, uninfringement. So, for example, in Section 35, it would affirm the rights of Indigenous peoples, but also too that these rights are not absolute. So they get interpreted in these concepts such as duty to consult and accommodate get triggered, and then negotiations that Crown exist for many Indigenous nations. And also, like I mentioned, for the Royal Proclamation, assuming sovereignty as the sole Crown and dealing with Indigenous peoples of the British monarchy. And so the policies reference this relationship as being sui generis, unique. And so a unilateral approach as well is that the absence of these information, having that paternalistic approach. So another call to action that was highlighted in the 94 calls to action is call to action 47. That references the top one, principal discovery. We call upon federal, provincial, territorial, and municipal governments to repudiate concepts used to justify European sovereignty over Indigenous peoples and lands, such as the Doctrine of Discovery and terra nullius, and to reform these laws, government policies, and litigation strategies that continue to rely on such concepts. So the Doctrine of Discovery predates contact of Indigenous peoples from Columbus. It was actually first papal bull that was issued in 1452. And so the Doctrine of Discovery is a culmination of 3 papal bulls. And so they do reference from particularly the Spanish and Portugal, and then later adopted by Britain and France. But you can see here that during this period of time, through the Doctrine of Discovery, established a demarcation line to split the world in half between Spain and Portugal. And it says, we assign to you and their heirs, successors, kings of Castile and Leon, all islands and mainlands found and to be found, discovered and to be discovered towards the west and south by drawing and establishing a line. That said line to be distant 100 leagues towards the west and south from any of the islands commonly known as the Azores, Cape Verde. So this was the justification for the colonization of the Americas, which is known as the Doctrine of Discovery. And for it to not be repudiated, you actually see quotations such as the 1823 Johnson versus Marshall case. Even Canadian court cases have cited the principle of discovery. So that creates ongoing challenges with regards to the treaty relationship between Indigenous nations and that Indigenous Crown treaty process. So challenges with treaty, when we look at the Indigenous Crown post-Confederate, is some of these written treaties. So there are documentations of written treaty that exist pre-Confederate, Selkirk Treaty. And so when we look at the written treaty, the oral versus written, much of the interpretation falls into the perspective of the Crown. In legalistic terms, language such as ceded, surrendered, and yield their ancestral rights. So there was an important court case in 1999, which was the Marshall case, which established principles of treaty interpretation to ensure that, and also in 1985, these court cases that assisted to remove some of those heavy colonialistic perspectives of the treaty-making process. So the Crown's perspective at times views simply as a real estate transaction and a colonialist view. So that's why I was mentioning here is about what is being brought forth in the treaty process and on how are we continuing the original spirit intent of the treaty. And so some of these infringements were continually reaffirmed, such as saying in the Sparrow, there was from the onset never any doubt that sovereignty, legislative power, and indeed the underlying title to such lands vested in the Crown. And so though these Supreme Court cases occurred primarily as a result of Section 35. So there have been decisions that existed prior to 82, but now it gets deferred to Section 35. And you have these in the Marshall decision, 9 principles of treaty interpretation. And so the treaty interpretation is to also ensure that these principles would retract from any of these ongoing misunderstandings in the relationship of the Crown. So to read these out, 1, Aboriginal treaties constitute a unique type of agreement and attract special principles of interpretation. Treaties should be liberally construed and ambiguities or doubtful expression should be resolved in favor of the Aboriginal signatories. So also to any misunderstanding would also work favorably for Indigenous nations. The goal of treaty interpretation is to choose from among the various possible interpretations of common intention, the one which best reconciles the interests of those parties at the time the treaty was signed. So when we're looking at these treaty interpretations, also as well, what becomes a challenge is having it encapsulated at the time of the treaty being signed or treaty being agreed to. So how do these treaties carry forward to when we modernize, say, for example, in 2021, if you're going hunting and you have a treaty that's agreed to, does that mean you only are excluded to using a bow and arrow? Or an outdated form of hunting, like a musket. So using things such as modern tools and modern applications that support your livelihood today. So it's not a frozen point of reference. So the interpretation of the treaty also allowed to carry forward for modern usage. Now, the words of the treaty must be given the sense which they would naturally have held for the parties at the time. Technical or contractual interpretation treaty wording should be avoided. So these are heavily legalistic forms of interpretation, but these are for awareness purposes, the conversations that occur in Canadian law and constitutional dialogues when dealing with lands and resources of Indigenous peoples. And so, for example, why aren't these promoted in the educational processes for all Canadians to be aware with regards to case laws, Supreme Court cases that impact the livelihood of Indigenous peoples? So if we are to move forward in meaningful reconciliation, these are these undertones that are still ongoing and existing, and they impact all Canadians, whether we are aware of it or not. And unfortunately, these get relegated to a very simplistic form of understanding through actions such as land acknowledgements. And one thing I do want to highlight, for example, is many Canadians implement land acknowledgements, and they may not know the reference to some of the legal ramifications associated with political crown representatives making statements. So, for example, if you look at land acknowledgements, why are they different between political, public, corporate groups? Reason being, it highlights that Indigenous crown relation. So, for example, when Premier Wynne was elected, it states acknowledging a traditional territory, the Mississaugas of the Credit, and also subsequently highlighting, today it is my privilege as Her Majesty's representative to deliver the first speech from the throne. So saying that I am a representative of the crown. And so that's, I find these double conversations that are ongoing in the era of reconciliation is that the Indigenous crown portfolio is very aware specifically from a legal understanding about the relationship to Indigenous nations. And many Canadians are moving forward in a manner and are not being provided with meaningful education as to with regards to, one, the spirit of treaty of which they originally intended for our original instructions, and then also two, some of these processes that are impacting the quality of life by not honoring the treaty. So what can we utilize to challenge all that and reframe and renew these relationships of being treaty people in Canada? Firstly, in 2015, the United Nations Declaration of the Rights of Indigenous Peoples was adopted of Canada. When the General Assembly first acknowledged in 2007, Canada was one of the 4 countries that was in direct opposition to acknowledging UNDRIP. But it's not a treaty convention. It's utilized and also not relegated just solely between nation states. It could be a framework for human-to-human interactions and relationships and best practice. So referencing the 46 articles. And also too, for if we are going to move forward in a treaty relationship as a community member, I would reference one of the clauses in any actionable item, which is establishing free, prior, informed consent. So for example, if you're going to acknowledge land and territory, and if we are going to move forward to promote reconciliation from a process of relationships, are both parties establishing free, prior, informed consent? So if we think back to some of the treaties that were enacted and some of the promises that were made, the Royal Proclamation, it had to go through that process to ensure that Indigenous nations consented and were informed about what the proclamation was being said in the document. But if you look at the numbered treaties 1 to 11, that process did not occur. They were promises made, but were not aligned with what the actual written documents stated. And so if we were to improve our relationships in best practice, we can apply those principles of UNDRIP to ensure that every time we are working relationship dealing with land, territory, or even just our day-to-day interactions between Indigenous non-Indigenous community members, ensuring that each and every party involved has free, prior, informed consent. And to close off, I just want to say that we are all treaty people, and some of these principles that we can establish are through respect, recognition, our role and responsibility in our relationship to treaty, and through a process of renewal and also restoration. My personal view is that we are not creating anything new for reconciliation. We are restoring some of the original instructions and relationships that have been granted to us, and also to honor the treaty that goes beyond just our human to human relationships and interactions, but for all the lands, all the waters, and all the beings that we share this country with, because we are going through an ongoing challenge. And in the era of reconciliation, we should all be concerned with climate change, the resource development extraction. And so if we think about this here, the close off that I mentioned in the cultural context is going back to here. If you look where I'm from, Niska, the Canada goose, the flock of geese, I always say they never share that position of leadership on its own. They always shift when they're flying, and that's a sense of shared responsibility. So if we are all treaty people, we should have a shared responsibility to each other as individuals, to our families, to our communities, and also to continuing our nation-to-nation relationship. As a participant in treaty, I inherited this from my family, my community, and my nation in Mushkegowaskie, and also I apply those principles of treaty in my own day-to-day life. And so I'm still always in a lifelong learning process as well. But I invite anyone that's looking to educate themselves about treaty is to go beyond the facts, points of reference, and to give life to what treaty means and how we can better the future for all Canadians. And so for any aspect of continued learning, all I want to say in my language, and I'm still learning, what my family passed on to me was Kinanas, Kumitana, Misway Kagwan, Kaktenberg Takshi, Kikagwich, Jimitana Maganush, Kikijigak, Misway Kagwan, Jimino Bunek. And what my family told me when they, and also for the challenges of my own pronunciation, but what they told me is they say, you give thanks for yesterday and you give thanks for today. So for this process of treaty is that one day at a time and one step at a time. So with that, I hope there is a point of reference for continued learning, and that to get the conversation started into knowing that we are all treaty people. Thank you, miigwech.